Hi, I'm Graeme Blank. I'm a barrister from Australia. I have been a barrister for about 12 years and doing commercial and corporate law, as well as some family law and personal injury litigation. I'm also a coach with Advocacy, and I'm accredited with NETA and with the Australian Bar Association coaching programs as well. With me today is Rafe Foreman. He's a professor of law at the University of Missouri in Kansas City.
That's right.
He's been a trial lawyer for 21 years in personal injury and specialising in criminal defence.
That's true.
That's right. And you've also been teaching in the Trial Lawyers College for, I think, 10 or 11 years?
That's right.
Okay. What we're going to be doing with you today is just talking about a way of doing case analysis. We're going to be taking a very simple case. Everyone's heard of it. It's Jack and Jill. As you know, Jack and Jill went up the hill to fetch a pail of water. Jack fell down, broke his crown. It's clearly a negligence case. Jack's had some injuries. He's needed some surgery. He's got a plate in his head, and he's got a psychological trauma as well. We're just going to be mapping out, using this technique, some of the basic elements for the negligence claim, so that whether we're for the plaintiff or the defence, we can see what information we need to prove the case and the evidence that we need in order to establish those elements. So, Rafe, if we start with the basic elements themselves, if we're looking at a negligence case, as we are here, what are the broad elements that we need to prove a claim in negligence?
Well, we've got duty, breach, cause, and damage. I didn't mean to go too fast.
That's right. So duty being the duty of care.
Right.
And then we have breach.
Right.
And then we have cause, or what we call in Australia causation.
Mm-hmm.
And then we have damage. Now, what we're doing here is we're identifying at a very broad level the topic that we're looking at. In this particular case, we're looking at the legal elements, but you can be looking at anything else. You can be looking at a particular issue in the case, such as bias or identification in a criminal case. And once we've got our broad aspects, we then break that down into some more detail. So, for example, in our duty of care, one of the issues we need to look at will be the standard of care. And depending on what kind of agency, whether it's an individual or a government agency, we might have the duty of care of government, of an individual. And so there are different tests that apply, and we can keep breaking that down further. Causation, we can do the same thing. We can break that down into the acts that caused something or the omissions. And those acts might be actual conduct by someone, or they might be words, for example, depending on the kind of claim that you've got. And what we're doing here is we're building a map which sets out all of the things that we need to be considering. And importantly, we're doing it before we've actually looked at the detail of the case. We know that we have to look in a negligence context because we know the type of case. But we're not looking in detail at the facts yet, because that will start to channel our thinking, and we might then miss other important aspects. So what we're now going to do is focus particularly on the damage question, the actual assessment of damages side of the case. All right, now you'll recall on the previous board, one of the elements within the negligence was damages. So what we've done is we've basically taken that element and started a new page. And when you're preparing for trial, whether you're doing it on your own or in a group with your client or just a team, what you can be doing is just have individual pages for all of these items. And then when you're preparing, you can gather them all together and you just sequence them in whatever order that you want. Mm-hmm. One of the things that you can then do later on in preparing for trial, you can actually use this as the basis for your direct or for your cross-examination, because you can ask specific questions, and this can help you organise the sequencing for those questions as well. So what we're going to do here is just look at damages. Now, we've already written up some examples of categories for non-economic loss, but let's focus a little bit for a moment on economic loss. Now, Rafe, what are the categories of economic loss that we might be looking at?
Well, one may be lost wages.
All right.
If Jack had a job.
All right, wages.
He may also have some hospital bills.
All right. Now, if I can just pause you there for a moment. Mm-hmm. Hospital bills are a subcategory of a larger category, which would be medical expenses.
Mm-hmm.
So we want to always keep it broad, because then we don't forget particular categories, and then we can keep breaking it down as we go.
True.
So we have medical expenses, one of which you said was hospital. Okay, anything else?
Well, do you want me to get to the subcategories of medical expenses?
Sure, we can do that.
You may have doctor bills,
Okay, yeah,
rehab bills for his rehabilitation.
yeah.
He may have some diagnostic treatments.
Like MRIs and X-rays and things.
Yes, correct.
I might just abbreviate that for now for MRI,
Right.
but you would normally broaden that to diagnostic and then go down further into those.
Right.
All right. So that's some medical bills. Is there anything else we might have? Well, I suppose there's more in wages, isn't there? I mean, because you've got the actual wages, you've got your 401k or superannuation, as we call it
Right.
in Australia. So in order to work out the wages, we need to know what his net wages.
Right. Maybe he may have insurance benefits like, health insurance, retirement.
All right. And you'll see what I've done from what you just
Yeah.
said there was I've gone back to benefits,
Mm-hmm.
one of which would be health, but he might have a gym membership or a car.
True.
All right. And so we can keep breaking it down into these subcategories. Now, I put circles around some of these categories for no particular reason. We call this the circles method because we've just put circles around it. But the advantage of doing that is it just helps us track where our key points are and then the subcategories off that. So once we've spread all of this out, what we can then do is start applying the facts of the case. Now, one of the things that we have in Australia, which we haven't got up here, is loss of opportunity.
Mm-hmm.
Would that be a category that you'd have over here as well?
I would put loss of opportunity under non-economic loss because it's not something that we have a objective bill for, but it is a definite non-economic loss.
Right.
We also have mental anguish, which is different than pain and suffering, and so I would put a category for mental anguish under non-economic loss.
All right. So we can add in mental anguish there as well. And the advantage of this process, you can see, is we've been focused over here. Mm-hmm. We've suddenly thought of something else in the group, and something can get added in. You can give individual participants, trial lawyers or students, particular categories to go and work with. And once this is done once, you've got yourself a template for every personal injury case you ever need to run. So let's plug in some of the facts that we know in this case.
Before you plug in the facts, can I make one comment?
Sure.
These elements of damages are also the categories of pleadings. In our jurisdiction, you're required to plead and give notice of the damage that you're seeking. And these would be the exact elements that plaintiff's lawyer would want to include in his petition for damages.
All right. And we do the same thing in Australia because we've got pleadings, and we'd call these the particulars as well. The pleading being the damage, the particulars being economic loss and the subcategories, and non-economic loss and those categories, as you was just saying.
Exactly.
So it's a very simple way of setting out your pleadings as well. So in this particular case, for example, we know that Jack used to work, he was earning $200 a day or $1,000 a week net. So we know that that's his net wage per week. His 401k was, our rate's 9%. I don't know what's your rate.
Let's use 10 so it'll be easy.
Keep it at 10%. If my maths is right, that would be what, $100 a week?
Yes.
He had a car allowance which was worth $15,000 a year. He needed some surgery. He had doctors and hospital bills which were $10,000. He's needed 3 months of rehabilitation, and in that I'm including the psychologist for now. I would break that down into more detail, and that's been $5,000. And the MRI, I'm not sure how much an MRI costs here, but
one's usually around $3,000.
So what we'd need to do is actually find the medical expenses and we'll plug in that number. But for now, let's assume it's $3,000. So now we actually have this information. What we don't know yet, which means we can ask Jack, or depending on the type of case, we might be getting the information in a deposition from somebody else, whether he had health benefits. We can ask him other questions about those other factors as well. So this gives us an idea of what we have from the information that we already have and where we need to make more inquiries through discovery or some other process.
Before we leave this diagram, let me make a comment about pain and suffering and how you arrive at these figures, because lawyers always struggle, as do clients, with how do you determine the amount of pain and suffering, emotional distress, mental anguish. And so first let me say that pain and suffering, for example, can be broken down into other categories. Right. From the time that Jack was injured up to the date of trial, that is pain and suffering in his past. But his pain and suffering is not going to stop on the day of trial, so he's also entitled to a future recovery for the future pain and suffering that's going to be caused by the actions of the defendant, if any. And so this can break down further. Some derivative of each of these may be based on your economic loss, for example. You'll come up with a total figure, and let's say that his total economic loss turns out to be $100,000. You may use a multiplier and ask the jury for 3 times his economic loss, so $300,000 for this element, and a different multiplier for each one. There's no set rule, there's no set standard, but there is an equation that is frequently used, and that is the multiplier of the economic loss used to categorize each one of these. Right. So
that's an interesting way. It's a very good point that these need to be broken down. And of course, this isn't a complete list here either. This is an example, because you've got other expenses as well. You might have modifications to your house, to your car, something that isn't medically related. In Australia, when we're calculating damages in the general damages sense, we use a comparative table. So usually other decisions that have been made give us a range of figures. For someone who's needed 3 surgeries and they took 2 years to recover, they might get a certain amount of money for general damages. General damages being a grouping of all of those. Mm-hmm. And then you just try and get a sense of the degree of severity of this case compared with those. Remembering, most of our cases don't have juries in civil cases, so what we're doing is relying on the bench trial decisions. So you've got a fairly consistent line of damages, and we don't have punitive damages either. This is the only damages that we would be getting.
Okay.
I'd just like to show you something else, Rafe, because once we've done this preparation in case analysis, this can be the basis for our deposition, or a basis for a direct examination, or as we call it, examination in chief, or even cross-examination. And the way you do it is this. What we've been doing here is we've been taking things from its most general to its most specific. Whenever we're doing a direct examination or examination in chief, you want to have 1 fact per question. So now we have our 1 fact per question. That is our 1 fact. That is 1 fact. So in direct examination, we have to ask an open question to let the witness give us our answer. So we would ask, for example, Jack, tell us about your wages. How much were you earning? Well, my net wage was $1,000 per week. Did you have any superannuation on that? Yes. What was the rate? 10%. So I was earning $100 a week on top. So all I'm doing is I'm asking here the question to get out this answer and let the witness give me this answer. And at this point also, I can be making references off to other documents which might be tabbed in your trial brief at document 17, which might be his paychecks. At which point you left a note to yourself, have a look at this document, Jack, what is it? That's my paycheck. It shows my $1,000 a week and my 401k. And that way you've got a reference on here as well as to all of the documentary evidence that you need to be tendering as you go along. And you can have lots of references so that all of the documents that you need on that particular topic have been brought together as well. I often have to run trials where I'm given the file a couple of days before the trial, and I have to sort all of that information so that I can then present the evidence. And I find this is a very fast way of putting all of that information together in shorthand, so I know exactly which documents I need when I need them. And when I turn to the next page of my brief and it goes to disfigurement, I can just put the reference immediately over here, and I'm not sorting through lots and lots of sheets of paper. Mm-hmm. In cross-examination though, you do the opposite. You still want 1 fact per question, but what you do is you actually put this fact as the proposition to your witness. Jack, you were earning $1,000 a week, weren't you? Yes. You were getting $100 a week in superannuation? Yes. You also had a car allowance of $15,000 a year? Yes. You had doctor's bills of $10,000? Yes. Now, of course, in cross-examination, we wouldn't simply be putting the witness's evidence back in. We'd have a purpose and a direction. But the form of the question is clear, and the material is already here. It's just a question of what we then want to do with it for an effective cross.
For example, I may say, Jack, you were earning $1,000 per week before your injury, correct?
Yes.
And after you went back to work, you're still earning $1,000 per week after your injury, correct?
Yes. And there we have no economic loss.
Right.
Great.
Okay.